Hi, welcome back to La Belle Vie, the Good Life Network, and our law and crime content. So today I was going to wrap up the Sarah Boone, Florida v. Sarah Boone case discussion for a while because, as I mentioned in my last video, the court has moved for a continuance and the case is now set for trial on April 10th with a final pretrial conference to be on March 28th. I would, I, I think it's 50-50 if that goes. I wouldn't be surprised if there's another continuance, but a lot of work has been done. And so I was going to put a video up on a lot of that work that's been done primarily by her first attorney. And lo and behold, I go on the docket and look, we've got another letter from our favorite defendant, Sarah Boone. So I thought I would go through that and then I'll do the other video with the other motions because there's quite a few experts that have been appointed in this case, in addition to the one that I mentioned that was that has been that is going to be retained to discuss a potential defense of battered spouse syndrome or intimate partner violence that I mentioned on last Wednesday's video. So, okay, so let's get to. All right, so here I think it was just filed in the court docket. It was mailed before the pretrial conference. You see, it was mailed on January 10th. It was referred to the judge, so that's why we have a copy. But anyway, she writes to Mr. Bankowitz. She says hello and Happy New Year. And she's then gets right into not having heard from him, which, as we know now, he apparently had COVID. But in any event, she's talking here that it's her understanding that she was supposed to, the court had ordered him to speak with her, and I'm still not aware and what's going on with our pretrial conference. So again, understandably, she's trying to figure out what's going on. But in the meantime, she puts forward, I guess, her position on various things that have gone on in her case. She first talks about the pretrial conference and again reiterates that she wants to be notified and she doesn't know what time it is and it's her right as it is to attend these hearings. So she wants to attend the hearings. She's talking about here a waiver and appearance. I'll have to go back and look in the file for this. This probably was something that was filed very early on in her representation in the case. But in any event, she's saying that she wants a copy of this waiver of appearance and she's not waiving any future appearances. And she wants to be updated on every single thing in her case, which is fine. That's her right. Okay, this is where it starts to get a little awkward. So she says, reason for withdrawal. It was not made known by you as my attorney or stated by the judge to the court during the status hearing. So the reason, she doesn't know why. I was completely blindsided and still massively confused for the attempt as our attorney-client relationship hasn't even been established from the 2 hours we have spoken. As of the now 4,536 hours, I guess, he's represented her. And the general information it was when we actually did. If you had genuine, legitimate concerns, I thought from a professional, moralistic standpoint, you would have discussed with me or at least mentioned rather than being uncommunicative for almost 6 months, an entire half of another year, for me just sitting here with nothing to show but the perpetual question marks still over my head. She likes to talk about the question marks over her head. But in any event, certainly you can see that she's frustrated. I would have hoped if you were unable to maintain your workload, which still presently includes me as your client, you would not have made the decision to take on my case. He was appointed. And even give me selling points and all your capabilities and resources. Well, I think that's a little rich given that he is a court-appointed lawyer. This is not a private retention of counsel. So, but in any event, why? Please help me understand. We are supposed to be working together and for each other rather than against. It worries me futuristically. Also, I have not to date received the copy of your withdrawal. Judge Wooden said I was included. Please give me a copy. Okay, phone account. This is interesting. It was previously told to me by you in our one in-person meeting, 8/22, that you already had this set up and were having your assistant look into into so we could use. After not answering any of my calls, the few I did make, an attempt to touch base with you to provide requested information you asked me for. So that's interesting because if you remember her September letter, she was talking a lot about these daily phone calls she was making. So I'm not sure, maybe there wasn't quite so many as she was saying before. I don't know. Anyway, she does say then she stopped calling him and have not to date since September 2022. So she then again says so she says here basically that she stopped calling him and have not called him since September 2022. I kept hoping you would call me on or set up a visit, even for 15 minutes, which has not happened. Please help me understand why you gave me your personal cell phone number. Also, to clarify, you, the judge, etc. This is interesting. I did not avidly search for the statements regarding your public reprimands in 2015 and 2018. So I thought this was interesting. If you look in Florida, like I think every state, if you can see who is, actively a member in good standing of the bar, and you can look all that information up. There has been 2 reprimands for this particular attorney. The first one, it was not even anything to do with communications or with client issues. It was basically a reprimand for failing to pay some payroll taxes due to an illness. So that was completely unrelated to anything with client representation. Now, the 2018 reprimand did involve client representation and a communication issue. So, she's right to bring it up. I just thought it was interesting that she had found that. But in any event, here she's talking, I guess this came up in that status conference in late December. In an attempt to speak with you from no response to my letters or calls, seller office, when having someone look up any contact alternative, what do you want to bet? She made her ex-husband do that. And to confirm your address from a letter I sent that was returned, then resent, the reprimands were discovered, and for the same complaint as mine, lack of communication. Again, like I said, one of them was about lack of communication. The other had nothing to do with a client. During the status hearing, when I made this known, okay, so apparently she made this known at that hearing, I was not clear in the end if you were going to actually set up again the phone account to be used, which any and all callers, inmates must have established in order to speak to family, friends, attorneys, anyone. It is nothing new or extra, and all costs incurred can be submitted for payment to the court as you've done in the past already. This is how attorneys communicate with their clients here in OCCD. Another option, in addition to 45-minute video visits, 15-minute at-home visits, is at-home jail, in-person visits, and of course the postal service. It would definitely make sense to use in avoidance of even more time being exhausted in the length between any visits in the future, which will only help the progress of everything. Will you be utilizing? Discovery case materials. Okay, so in the status hearing, you stated you have 2 boxes of information that are out of order and unorganized. So that would have been the discovery from her prior lawyers. Have you organized and reviewed? How long have they been in your possession? When will we be going over? And I thought this was interesting. Is it extremely concerning this is all you have? It has been said there were 3, 5, 6, a ton from some of the attorneys prior on my case. I mean, it has to be Mr. Padilla, because the other attorneys, as we mentioned, really didn't do anything. It was all these conflicts. I'm still wondering, which is it and what is there? 3 years later, I'm still wondering. I have also put in numerous hours, pages, pen, ink. She's very concerned about ink, pen. Pen, ink of my own information, which I'm praying is in either of the boxes you currently have. Please let me know as the added amount of even more time to locate, receive, review anything missing from everyone receiving before then withdrawing will most definitely be extreme. I don't know what you have. I also could assist in organizing what you do have concerning it's all part of my case. I am eagerly waiting and more than willing to help with this and everything else. I just need to see what is there, which I have yet to 3 years later. Prosecutor, is there a new one in my case? I noticed his attendance during the 3 status hearing attempts and came to the conclusion there is. Since you have not communicated with me this or any information, nor an announcement made by the court, I do not know. If so, what is his name? What is his background? Mr. Bankowitz, I think there is a new prosecutor, which wouldn't be unusual given this has been going on for several years, but I can check. Mr. Bankowitz, you must understand how insignificant I have been made to feel with the never-ending debacles, hurdles, and stumbling blocks I have and am going through and still facing since becoming incarcerated. No one seems to listen ever. I refuse, absolutely refuse, to believe this, my entire experience to date, really is how our justice system operates. I refuse because, as said to you, Judge Wooten, the court, to everyone else in the status hearing, to anyone who truly cares, my reason is hope, never ending, no matter what, hope. This being the entire reason I am even here for my incarceration. I'm not quite sure what that means. Nothing is impossible with God, and I wait my day to say my truth and side of everything. Oh my gosh. I wonder if Sarah Boone's going to take the stand. Oh, man. Please don't give up. I have not and will not ever. I wait your response. As always, Mr. Bankowitz. Thank you, Sarah Boone. And then there we go. So, sounds to me like she really wants to tell her side of the story. And generally speaking, it's usually not a good idea for defendants to testify. It's not always the case. And depending on how the battered spouse defense goes, she may have to, because as I discussed Wednesday on my discussion of the battered spouse syndrome in Florida, if she is going to have her expert speak about her interview with Ms. Boone and her facts of her case, that will allow the prosecution to be able to interview her. And I just don't know if the defense is going to want to do that. So anyway, very interesting. Thanks again so much for joining. As I mentioned, I'm going to probably be doing long crime content once a week. Probably on Sundays, I'll do a follow-up. So next Sunday, I'll do one just on the final motions from Sarah Boone's previous lawyer and anything that comes up this week. I happen to plan on catching some of the Murdaugh trial, which is fascinating. I know a ton of people are going to be covering it, so anything I say on that will probably be something that I think is unique for my experience, or maybe something I'm not seeing that others are talking about. But in any event, Sundays is when I plan to do my long crime updates. But thank you again so much for joining, and I hope you have a wonderful day. And thanks so much. Bye.